Where was that, Jeff?
Let
Sorry.
me try that again. Page 2, line 4. A, at the time of the instant offense, the defendant was, and I can continue to read, but you can.
Okay. What I'm trying to get at, and what the DA's Association is getting at here also, is that, you know, you can be suffering at the time of the offense, right, from something that occurred a long time ago, psychological.
But Al, that's maybe a bill that you'll introduce, but it's not the bill that I introduce.
Okay.
So
Well,
if you want to introduce that, I'd be happy to co-sponsor with you.
no, that's okay.
I thought so.
All right. Can you talk about what you're talking about with community-based alternative programs?
Mm-hmm. And where are you finding that particular
This is in your sponsors memo.
in the sponsors memo?
Yes. 1, 2,
Oh, it
3,
could be
4.
probation. Is that what you mean?
Community-based alternative programs.
Right, which is, it could be probation. One judge might be able to, under the circumstances, given his discretion, given his ability to view that, grant probation to someone who is in front of them under this law.
Okay. And now, physical implications. Do you know how many cases you think this will, how many cases will arise
There
out of
were
this
some
legislation?
estimations made relative to the number of cases that this might be relevant to. Not a definitive listing of cases where it worked. I believe on the, let's say, we have estimated that there are less than 400 individuals who are currently incarcerated that this bill has potential effect. Less than 400, but not all 400. It is merely an estimation that they might be. They'll have to be judged because there'd be the application would be reviewed, the judge would decide no or yes. Additionally, using the figures that of people who were sentenced in 2014, they estimated that less than 500 would have been potentially eligible for domestic violence alternative sentencing. And I presume that's the individuals who were in front of the judge for new offenses in 2014.
Well,
but
there's
not a scientific, Al, not a scientific group of numbers, but a kind of a wide estimation of what might go on or who might be eligible.
So there's no time limit on this, though, right? A person could be incarcerated for, say, 10 years and then ask for this hearing.
Individuals who are in correctional facilities would have to have been there for at least 8 years before they would be eligible to apply for any provisions in this bill.
Right. And just going back so I'm clear on this, I mean, the standard of proof to show that you suffered from this, especially as time goes by, is it just police reports or court cases or court documents, or are we talking affidavits from family and friends to substantiate? Because, you know, over time, witnesses get lost and everything else.
Well, as I think we said in the beginning, one must be a court document or a police report. Must be a court document or a police report.
Right.
And the others may have other general information related to it, but we are counting on the judge to have to be anchored by documents that were already submitted by the police or by the court.
Well, already, I mean, a court document, I could submit, right, an affidavit to the court attesting to whatever.
But it would have to have, if they were incarcerated, it would have to have been in the trial that got them sentenced to, that they were sentencing for.
8 years ago.
Right.
Okay. And the cost of this, I think you say there's no cost, or they will save funds?
So here's the cost issue. So what is allowed is a public defender is allowed to assist someone if they get a hearing. And that estimated cost is about $4,400. If they continue to serve their sentence, every year we spend about $60,000 on every prisoner that we incarcerate. So the question is, one, whether or not you would spend $4,400 or have to spend $60,000.
Well, that's just attorney's fees, though, Jeff. I mean, wouldn't you agree that a lot of people that are sentenced to felonies are in state prisons?
Right.
So they would have to transport the person from the state prison to the local court, because they wouldn't do it in the court where the prison was. They'd have to do it in the court of conviction, correct?
Only if they get a hearing, right, if they get a hearing. But a transport is not going to run up to $60,000 a year, I don't believe.
All right, I'm out of time. I'll come back.
All right.
Okay, Mr. Goodell?
Thank you, Madam Speaker. Would the sponsor yield?
Will the
For
sponsor
Andy
yield?
Goodell, I would always yield. However,
Sponsor yields.
Thank you, Mr. Aubrey. I appreciate that. Under this bill, you would be qualified if at the time of the instant offense you're a victim of domestic abuse. That's the first criteria, and that abuse was a significant contributing factor. Is there any requirement in the law that there be a connection between the abuse itself and the defendant? In other words, under current law, certainly you have a defense of self-defense. It's certainly a recognized defense. But this doesn't have to. Is there anything in this law that requires a direct connection between the abuser and the victim as it relates to the crime?
because you're always so detailed, on page 2, line 9, such abuse was a significant contributing factor to the defendant's criminal behavior in the bill.
Let me give you an example, if I could. If you have a victim of domestic abuse and the abuser says, I want you to knock off the local liquor store and bring me the money or I'll beat you up. Is that a defense under this bill for the victim of domestic abuse in a defense for armed robbery?
Because you are excellent at using terms. So
I know I'm being set up right now.
Yeah, I know
Jeffrey.
you're setting me up. Right. So it isn't a defense. It is the fact that would allow a judge to determine whether or not there should be some altering of the sentence. Your conviction, I believe, stands, right? So it isn't about whether or not this will get you free or off from that conviction. It is about whether the judge can use that as a mitigation to the sentence that was imposed or will be imposed.
In the sponsor's memo, you note the high correlation of those who are incarcerated who also claim domestic abuse at some point in their life, correct? I mean, the first paragraph says 8 out of 10 have experienced serious physical or sexual violence during childhood. Is it your belief then that being a victim of domestic abuse while a child could be considered as a mitigating factor in a criminal sentence for a crime that was created as an adult?
Well, my belief is irrelevant in that case because it isn't the bill that we're debating.
But is it your intent that this bill would allow the judge to consider childhood abuse in determining an appropriate sentence for...
I think we answered the question that Mr. Graff posed, which was that it has to be in the a factor in the current offense that was getting you sentenced, if I'm not mistaken, right? At the time of the offense. So, and as you quite accurately posit, people who have been abused have, over the course of time, domestic abuse, whether it was young or not, have significant difficulties. But this particular legislation doesn't do that. It is at the time of the offense, what was the impact, and whether that was something, there was significant evidence so a judge would say, this act was influenced by the abuse that you were receiving at the time, and therefore we can look to modify the sentence.
As you know, often we've seen criminal trials. We get summaries sometimes in the news media where the defense is, I did all these terrible things because I grew up in a wealthy family, or I did all these terrible things because I was a victim of domestic abuse, or I did all these terrible things because my parents got divorced, or whatever. And the litany of excuses that go back almost to childhood is sometimes astounding, but quite common. Doesn't your bill open the argument that at the time I committed this offense, I was acting out my anger at my abuse that occurred 5 years ago or 10 years ago?
Not being a barrister or a lawyer, I could only say that this is not going to be a jury trial. So if that was presented, and most times I think they're trying to influence juries when they do that, would be my humble opinion. But in this case, what we are, there's an application put in front of a judge who will view this based on the criteria that we said. Does it impact right now what's going on with this case? And if it does, if it's substantial enough, then we'll have a hearing on it. So I don't believe that it opens the door for any more broader interpretation than that, Mr. Goodell.
And if I understood your answer earlier, the judge can consider the fact that you're a victim of domestic abuse at the time of the crime, even though the crime was committed not against the abuser, but against a third party, correct?
In this case, that could be the case, yes.
So, you know, if you're the shop owner who was just held up at gunpoint, or you're somebody else who is a complete innocent bystander, third party, and you were shot or stabbed or attacked or beat up, don't we want the punishment of attacking an innocent third party to be applied equally and fairly against all defendants?
Well,
I mean, why do we want to carve out some defendants and say you only get 1 to 3.5 if you shoot a shop owner if you're the victim of domestic abuse, but you get, 5 to 15 if you don't have any other excuse?
The person is still convicted, right?
Right.
So there's a conviction, and then there will be a sentence as there is in any other case. And again, this particular legislation deals with a list of crimes that are below some of the most violent crimes that we handle, right? Right. And the judge's ability to give whatever the existing sentence is 5 to 15 still exists. We're not taking away that ability for the judge to make that decision. We're just moving it from the DA who charges to the judge who decides.
Thank you very much. I appreciate your comments on the bill.
On the bill.
We are all sensitive to the problems that victims of domestic abuse face. There's no doubt about that. And we understand that sometimes victims of domestic abuse will lash out at their abuser. We understand that. We as a society have recognized, in fact, that in many instances that is a valid defense of self-defense. But this bill takes a valid defense of self-defense and takes it one step further. And what this bill says is that if you're the victim of domestic offense, you can commit a crime against a third party, not the abuser, a third party, an innocent third party. And when it comes up to sentencing and you've been convicted of attacking an innocent third party, you can stand up and say, you know what? I'm a victim of domestic offense. And my abuser said if I didn't knock off that liquor store, or if I didn't hold up that person, or if I didn't beat the living daylights out of somebody my abuser didn't like, I was a victim of domestic offense. And therefore, I shouldn't serve the same amount of time as everyone else in the state of New York for the identical crime committed against an innocent third-party victim. We have an obligation to protect innocent third-party victims. Each one of us, we have that obligation to protect innocent third-party victims. And we expect people who attack and injure or rob innocent third-party victims, we expect them to pay the consequences. And while we're sympathetic to the fact that they might be living in poverty, or they might be very rich, or that they might have had a good childhood, or they might have had a bad childhood, at the end of the day, our first obligation is to protect innocent third parties. And this bill, which says you can attack an innocent third party and get a reduced sentence if you've had a bad childhood, or you've been a victim of domestic abuse, or it's otherwise affected you, and that's wrong. We have to protect innocent third parties first and foremost, and this bill goes too far. For that reason, I'll be voting against it and recommending that my colleagues do the same. Thank you, Madam Speaker.
I gather not.
Mr. Goodell, will you yield?
To Mr. Aubrey, I'm always happy to yield.
So
You will
I
yield.
understand that you're in the height of your summation, and maybe you might have mistaken the words that you said. However, you seem to indicate to me that this legislation, if you had a bad childhood, would come into effect. And we, I think, established in our colloquy that that wasn't the case. And I just didn't want you to go on record, making a statement that we thought we'd already resolved.
Thank you very much, Mr. Aubrey, for bringing that to my attention. So let me make 2 points. First, as you know, we all have a memorandum in support of legislation. And that legislation includes, as part of the legislative history, the memorandum. And so this memorandum says, quote, domestic violence and women's incarceration are inextricably linked. 9 out of 10 incarcerated women have experienced some violence in their lifetime. 8 out of 10 during their childhood. So the memorandum of support specifically references their entire lifespan and, in particular, their childhood. Now, the bill language itself requires that the judge find that the domestic violence at the time of the incident was a significant factor. And all I'm saying is, with a reference to childhood domestic violence and domestic violence throughout the entire lifetime, it opens the door for creative defense attorneys to point out that at the time of the violence, this person no longer had an adequate respect for the life, health, liberty, and property of third parties, and it was a significant contributing factor to their crime against those third parties. Now, obviously, we can clarify the memorandum of support and remove the references to lifetime or childhood abuse. And I would welcome that amendment. But I also think we need to make it clear that under the undisputed language of this bill, a person can apply for a break in their sentence when they committed a serious crime against an innocent third party.
And that consideration by the judge has to be tied to the crime at the instant. So a definition, Mr. Goodell, of what abuse is in our bill of support is only added to there to sort of expand the knowledge of those who might read it if they happen to not pay much attention to domestic violence, which unfortunately lots of people don't. So as long as the bill identifies exactly what I said, which you admit, then I'm fine. Thank you.
Thank you, Mr. Aubrey, and my point remains. We need to be mindful of the rights of innocent third parties, and we should not provide for a lower penalty when innocent third parties are attacked or are the victim of a serious crime. For that reason, I still oppose it, but I appreciate the clarification, Mr. Aubrey.
Mr. Graff for a second.
Will the sponsor yield?
Will the sponsor yield?
Certainly, Al.
Yeah,
Yields.
Jeff, just in your bill, on page 2, when you have a Class B felony that's applicable here, right, we give them how much they can sentence, the judge, how much he can sentence the person to, how much discretion he can have. And formally, for a Class B felony, it was 6 years to 25 years, correct? You can see the crossout. Start at page
Must not
39.
exceed 25 years. On line
39, page
I got
2.
it.
So it was 6 years to 25 years for a B felony, correct?
Right.
And we're reducing it to the judge's discretion that he can sentence them to 1 year, but he can't exceed 5 years.
So the existing range is still available.
I can't be out of time. I just started.
I still have some power
Never
on
mind.
the roster. And I certainly don't mean to use it against you. Absolutely not. I would never do that. So, I'm sorry. You can still, the judge could still give the 25 years based on his review of both the application, well, if the application fails, there's no question, but then the hearing that is conducted at which victims are permitted to speak and testify.
Right. You have a 3-part test, right, for the hearing. There's a 3-part test.
Right.
And as long as that person meets the 3-part test, the judge then has to go to the sentences recommendation for this.
He may. The judge must find. He's not mandated. He must find in his discretion that these items all rise to the level that a reconsideration is appropriate.
Okay. Well, if they're doing
And
a
it's
hearing,
not unsimilar to what I am sure district attorneys do when they decide to charge.
Yeah.
Right? Because they get a set of facts from the police and they investigate and then they decide, well, I think we'll go for this charge on that case because of that's what is recommended, that's what our office says. We're only saying that the judge, and we've said this before, is in the place and the position also to make that decision.
okay, but the way I read this, Jeff, is if a person petitions the court to get a reduced sentence under this bill, and then there's a 3-part test, correct? Mm-hmm. And if that person proves the 3 parts, or the judge concludes that they've proven each part, each of the 3 parts, then what happens is, on a B felony, right, after a hearing, he concluded that, yes, he satisfied part 1, satisfied part 2, satisfied part 3. And he ruled in his favor that, yes, you satisfied this test. Then he's limited to the reduced sentence guidelines.
No, he can give the original sentence. He's not limited. He's given discretion, not limited. Limited is if he could only do one thing. Discretion means he has the full range of options in front of him as a judge.
Okay.
Yeah, we're always in May. We never
All right,
will.
but we're reducing the sentence from 6 to 25 to 1 to 5 years, his option, right?
We have the option. You
I
keep
said
saying the judge has the option. Like you can sit down and not talk, or I can stand up and talk. The judge has the option to determine what the sentence will be based on this application.
Okay.
And the criminal history record, he'll look at everything. We trust him.
All right, let me ask you this. Let me try this. Here's a scenario,
Okay.
okay? A police officer responds to a domestic dispute, okay? He's standing next to the abuser, handcuffing him, okay? Now, the person that was abused takes a gun, shoots towards the police officer and the abuser, kills the police officer, all right? That's manslaughter, aggravated manslaughter, B felony, that would fall under this, correct?
My learned counsel says no, because that would be murder one.
Well, not if it's not intentional. If they didn't intentionally try to shoot the police officer, okay, then it's manslaughter.
Right. Well, I guess we'd have some argument. I bet you the charging district attorney would not give him manslaughter.
Yeah, that's why we get paid the big dollars in a courtroom, because we can argue anything, any way.
Any kind of way you want. Absolutely. You say so. I'm
Now,
with you.
the last thing, Jeff, and, the sponsor memo, right, becomes part of the law in that what my colleague pointed out, where he pointed out the language that said it could be, any of these things from when the person was younger, right, or was a child and it affects them now. This sponsor memo can actually be, you would agree, this could actually be an exhibit in a court to prove legislative intent of what you intended to do with this legislation. Would you agree with that?
Al, that also part of that becomes the record of this debate. And so we've indicated exactly what I believe those statements are, not that they are to open up any past Whitcomb. So the legislative record probably overrides the sponsor's memo, if that were the case. But because I like you and I trust you and I really like your opinions, I'm going to look at the sponsor's menu
I appreciate that.
after you vote for my bill.
Well, we all have to have goals in life, On the bill,
On the bill.
I think we can agree to disagree on this legislation. I think this legislation does some really dangerous things. I think it doesn't take in consideration the victims of these crimes. Some of these crimes are horrific in nature. And, for instance, on a B felony, we're going to go from a maximum sentence of 25 years, we're going to go down to 5 years. Okay? So I think a lot of times what we do is in plea bargains, we treat plea bargains as contracts. So we're going to go in and undo all of these contracts. And, you're looking at 8, 10 years down the road. This is going to be a great expense to the state. And not to mention, it's going to be a catastrophic scenario for victims of these crimes. So I would encourage my colleagues, and I think we need some redrafting of the memo that will become part of this bill. I would encourage my colleagues to vote no on this bill after considering the price that the victims will pay. Thank you.
Read the last section.
This act shall take effect immediately.
Clerk will record the vote. Ms. Peoples-Stokes to explain her vote.
Thank you, Madam Speaker, for the opportunity to explain my vote. I'd like to
Members,
commend the sponsor of this legislation for really, stepping out and dealing with an issue that, as a country, we have not handled well of late. We have spent decades taking discretion from judges after they've prepared themselves through law school, getting elected and or appointed. So the opportunity to give back discretion to the people who are in charge or should be in charge of making or looking at all of the legal facts and making the right decision, particularly in circumstances where people have been unfortunately hurt and or abused. So I do really want to commend the sponsor on this, and so I remove my objection and vote in the affirmative.
Ms. Peoples-Stokes in the affirmative.
Are there any other votes? Announce the results.
Ayes 85, noes 35.
The bill is passed.
Assembly 9628, Calendar 493, Ms. Weinstein, an act to amend the Family Court Act and the Criminal Procedure Law.
Read the last section.
This act shall take effect on the 90th day.
Clerk will record the vote. We have more. Are there any other votes? Announce the results.
Ayes 102, noes 0.
The bill is passed.
Assembly 9686, Calendar 519, Mr. Bronson, an act to amend Chapter 363 of the laws of 2010.
Read the last section.
This act shall take effect immediately.
Clerk will record the vote. housekeeping and resolution. Are there any other votes? Announce the results.
Ayes 99, noes 0.
The bill is passed. Mr. Morelli.
Yes, thank you, Mr. Speaker. Do we have any further housekeeping or resolutions?
We have housekeeping, Mr. Morelli. On behalf of Mr. Crespo, Bill number 5980, Assembly Bill recalled from the Senate. Clerk will read the title of the bill.
An act in relation to requiring a study and report on banking products and services.
Motion to reconsider the vote by which the bill passed the House. Clerk will record the vote. Clerk will announce the result.
Ayes 136, noes 0.
The bill is before the House and the amendments are received and adopted. On a motion by Mr. Blake, page 4, Rules Report number 14, Bill number 9174, amendments are received and adopted. On a motion by Mr. Lenthal, page 13, calendar number 123, Bill number 2699, amendments are received and adopted. On a motion by Ms. Simotis, page 24, calendar number 273, Bill number 7191, amendments are received and adopted. We have numerous fine resolutions, which we will take up in one vote. On the resolutions, all those in favor signify by saying aye. Opposed, no. The resolutions are adopted. And now, Mr. Morelli.
Yes, thank you, Mr. Speaker. Would you please go to Mr. Crouch so that he may make an announcement?
Mr. Crouch, for the purposes of an announcement.
Thank you, Mr. Speaker. There'll be an immediate Republican conference in the parlor. It'll be brief.
An immediate brief conference in the parlor for the Republicans. Mr. Morelli?
Yes, thank you, Mr. Speaker. A reminder that at 5 o'clock there will be the intern mock session, so while you don't have to go home, you can't stay here. And with that, I now move that the Assembly stand adjourned until 3 p.m. Wednesday, May 4th, tomorrow being a session day.
I ended every party with that. The Assembly stands adjourned.